It's showtime.
People should not be afraid of their governments. Governments should be afraid of their people.
You know, the right to bear arms is because that's the last form of defense against tyranny.
Washington is fundamentally corrupt. There are more words in the IRS code than there are in the Bible.
Made in America, heard around the world. You're listening to Blunt Force Truth. This is Mark Young. My co-host and brother-in-arms, Chuck Woolery, is a little under the weather today. This is one of my favorite shows of the month. This is when we continue our continuing education on the Constitution with UCLA Professor Adam Winkler. And I am so excited to do this. Adam, welcome back to Blunt Force Truth.
Hey, thanks so much again for having me. It's always been a pleasure to come on, and I'm enjoying our tour through the Constitution of the United States.
And I want to tell you something, Professor. I get emails, tweets, comments from people saying how much they appreciate you and how very even-handed you are with the Constitution.
Oh, well, that's very kind. You know, I am a professor, and I like to, be open to all different kinds of viewpoints. The Constitution is one of those things that we fight a lot about, and there's a lot of reasonable positions taken by both sides on issues of the Constitution.
Well, today we're going to work our way through Amendment 9 through 15. Some of these are short, but some of these are really wonky, and I got to tell you, I'm eager to get to number 12 because I want to see how that changed, because that doesn't function the way it does there. So why don't we kick this off with Amendment 9? Let's get started. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Well, this is a really important amendment in terms of our understanding of the Constitution, but at the same time, an amendment that's been pretty moribund in the courts themselves. In other words, the Ninth Amendment is rarely cited by the courts as an important constitutional provision, but just reading its language tells you that it is important, that just because the Constitution recognizes certain individual rights does not mean that others are not retained by the people. And this was important because, remember, Madison and some of the other founders were opposed to adding a Bill of Rights to the Constitution. And one of their concerns was that if we add a Bill of Rights to the Constitution, then only those rights that are enumerated in the bill would be protected. And they were concerned that no effort to list the fundamental rights of people could ever be exhaustive and complete. And so this provision recognizes that there are rights other than those rights that are listed specifically in the Bill of Rights.
So can I understand something here? I want to switch over to like a George Soros philosophy of open society. So in the open society, the belief is that rights they're not from God or from the Creator, that the rights are given to you by the government, and those are the only source of rights. If I'm understanding, the Founding Fathers were trying to say that rights don't come from the government, that they come from your Creator, that they're inalienable rights that you have regardless of what is in the Constitution. Am I getting that right?
Well, I think it's very much the case that the founders believed in natural rights, that you had a set of inalienable rights that were not capable of being enumerated in advance, but nonetheless very much present and very much an important part of civil society, and that you had those rights whether the government wanted to recognize them or not. The question for the Ninth Amendment is really the hard question is, what are those rights that are protected by the Ninth Amendment? And does the Ninth Amendment give sanction to courts to provide judicial enforcement of those rights?
What would be some examples of that? Yes.
Oh, sure. Well, for instance, let's think about some controversial rights these days. Think about the right to choose abortion. Well, arguably, that could be one of those rights that people have regardless of whether the government provides it or recognizes it. Or perhaps take the right to marry. Whether you want to get into controversies over same-sex marriage or not, the Supreme Court has long protected the right to marry and said that is a fundamental right. But of course, there's no listing of the right to marry in the Constitution, and arguably the right to marry someone of your choice was one of those rights that long predated the Constitution and arguably might be protected by the Ninth Amendment.
So, Professor, how did the federal government insert themselves I'm going a little off track here for a minute, but I think it fits here. How did the federal government insert themselves into such things as abortion or into marriage, which was never covered by the Constitution in the first place?
Well, part of the story is, I think, the idea is embedded in the Ninth Amendment, that just because the Constitution recognizes some fundamental rights that individuals have, that's not an exhaustive listing of the kinds of rights that individuals have. And that part of the Constitution's goal was not only to acknowledge certain rights, but to recognize that we were a land of liberty more generally. There was a controversial approach to this. You remember Robert Bork, who was nominated to the Supreme Court back in 1987, and he was famously rejected for the Supreme Court, and in many ways really exacerbating many of the problems with the confirmation process for Supreme Court appointments today. But one of Robert Bork's controversial positions was he said that the Ninth Amendment was kind of like an ink blot in the Constitution, that we couldn't, like, as if there was an ink blot that had hid some constitutional text. Well, if courts can't figure out exactly what it is, then underneath that ink blot, then they should not be sort of trying to enforce it. And he kind of said that about the Ninth Amendment, that it was kind of like an ink blot. We don't know what the rights are that are retained by the people, and that the courts shouldn't spend any time trying to figure it out. But of course, many people have fought against that view and argued that we should respect the Ninth Amendment as an important part of the text of the Constitution, like any other.
But and we can still stick with the Ninth for a minute, but when we lead into the 10th Amendment, wouldn't the Ninth Amendment and the 10th Amendment kind of go together, that those rights that aren't identified in the Constitution are then sent to the state to be states' rights, or for the people's rights?
Well, very possibly. So the 10th Amendment provides that the powers not delegated to the United States by the Constitution, nor prohibited to the states, are reserved to the states respectively or to the people. And the Ninth Amendment speaks in terms of rights retained by the people. The 10th Amendment speaks more in terms of powers. What are the powers of government? And I think the way to read these two amendments together is to recognize the Ninth Amendment recognizes unenumerated rights that people still have. As Randy Barnett, the libertarian constitutional theorist, says, that there's a presumption of liberty, that whatever you do should be thought to be part of your liberty, unless the government has been given some affirmative right to regulate that power. And the federal government has limited powers, and the states have much broader powers. But nonetheless, there may be some rights that are protected, even against the states.
So how does the federal government, help me to understand, our listeners to understand, how does the federal government, as an example, how did we create a Department of Education? Clearly, education was not something that the founding fathers thought was part and parcel of the Constitution. And I'm just using that department as an example.
Sure, and it's been a controversial department in recent years, to be sure. No, this is a part of the growth of the federal government over the course of the 20th century. You know, arguably, education really does have a profound effect on interstate commerce, for instance. And if Congress has the power, as we talked about in an earlier episode, to regulate interstate commerce, then it can regulate the things that lead to commerce, that create a vibrant commercial atmosphere, and arguably education is within that, and arguably education is not within that. But generally the courts have held that Congress does have broad power to pass laws regulating how federal government spends its money, and how it creates the conditions for good and effective commercial enterprise in a capitalist society.
So where would something like the EPA fall as an example?
Well, the Environmental Protection Agency, the EPA, right? There's no federal power to protect, quote unquote, the environment. However, we might recognize that almost all of the activities that threaten environmental degradation or climate change are indeed commercial activities, and indeed interstate commercial activities, big businesses, big factories that are operating in an interstate marketplace. And Congress clearly, in the founder's vision, has the power to regulate interstate commerce.
So when we look at, as we're looking at Article 10, and we're looking at powers being reserved for the states, we obviously have a lot of a lot of instances where the states and the federal government disagree on who has what power. Would that be a safe assumption?
That's right. And the 10th Amendment has played an important role both for liberals and conservatives in terms of limiting congressional power. So I'll give you two examples. In the area of guns, well, when Congress passed a law requiring background checks in the 1990s, the Supreme Court held that Congress couldn't force state police officers to conduct those background checks. They can require licensed gun dealers who are licensed by the federal government to conduct background checks, but they can't force state police officers, for instance, to conduct those background checks. The court said that Congress doesn't have the power to commandeer state office holders. So that's one where it's helped people on the right, say. But these days, it seems to be helping a lot of people on the left, too. For instance, the problem of sanctuary cities is largely a 10th Amendment issue, that because Congress can't force state officers to conduct background checks, Congress also can't force state officers to conduct immigration checks and ID checks for immigration. And as a result, cities, just as some cities refuse to enforce the background check provision because of the 10th Amendment, today there are cities that refuse to enforce immigration law because of the 10th Amendment.
Okay, so the 10th Amendment would be what gives the sanctuary city or sanctuary cities cover.
Well, that's right, because it says the powers that are not delegated to the United States by the Constitution are reserved to the states. And the Supreme Court has held that that means that states have some measure of state sovereignty that can't be interfered with the federal government. And one of those measures is the ability to control state office holders and state police. Federal government can't come in and order the state police to do things, but that's something that states have control over as a matter of sovereignty.
So did the 10th Amendment come into play during the Civil War?
The 10th Amendment was not actively read at the time of the Civil War. The first readings of the 10th Amendment really came at the end of the 1800s and the early 1900s, when Congress began to regulate more and more of the national economy. And that's when the Supreme Court sort of first said, hey, wait a second. Even if you're regulating the national economy, you have to respect some measure of state sovereignty as recognized by the 10th Amendment.
Now, the federal government also, I know there's a tendency in many cases of the federal government implementing authority over states by controlling tax dollars.
That's right. And that's not something that has generally been thought to interfere with the 10th Amendment. Generally, the courts say that if the federal government is spending its own money, that is to say the money that it raises through income tax or tariffs or other things like that, then the federal government can use that money at pretty much as it sees fit, so long as it doesn't invade on individual rights. And part of that is because there is a provision that we spoke of briefly in an earlier episode, the spending clause of the Constitution, that says that Congress shall have the power to spend money for the general welfare. So Congress can generally spend its money quite broadly.
Both parties have abused that. Both parties have benefited from it. I think both parties have benefited and at times abused the 10th Amendment.
I think that's absolutely right. I mean, many of these constitutional provisions at any one moment in time may seem very conservative or very liberal in terms of their political impact. But as our example with guns in the 10th Amendment and immigration with the 10th Amendment, that these overarching principles will tend to help different people at different times, and that they shouldn't be seen to be inherently partisan. In the 1990s, the 10th Amendment was used mostly by political conservatives to talk about state sovereignty and limiting the federal government. But today, we see in areas, for instance, immigration, and also with regards to medical marijuana, for instance, that the 10th Amendment is being used by political liberals to support a more limited government in the areas that they seek to have state regulation be predominant.
I think for those of us who claim that we love the Constitution and we want to adhere to it, we sometimes we need to accept it, that it's not always going to fall in the direction that we philosophically may agree with.
200 odd years ago, it set up a constitution that would correspond to all of anyone's political beliefs today. It was a different time and a different era. And the reason why these principles are so timeless is because they don't tend to favor, by and large, say, one side of the political spectrum over another. And that over time, as political coalitions and issues change, that the principles of the Constitution remain relevant for both sides in our political debate.
All right, shall we move on to number 11?
Number 11, this is not one of those constitutional amendments that gets a lot of attention. It provides that the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of a foreign state. And the basic idea of this is this was the first constitutional amendment that was enacted to overturn a Supreme Court decision. Back in 1793, soon after the founding, the Supreme Court held, in a case called Chisholm against Georgia, that a citizen of South Carolina, Mr. Chisholm, could sue the state of Georgia for unpaid debts that had been incurred during the War of Independence. And the founders thought that this was wrong, that you shouldn't be able to sue in federal court for these kinds of claims, that you should only be in state court. And so the founders themselves, just less than 20 years after the founding, adopted this constitutional amendment that would limit the power of federal courts to hear suits by citizens of one state against another state.
Or against the federal government itself?
No, this is really, it's saying that this is really just about limiting the ability of citizens of one state to sue another state. And so that it doesn't really pertain to trying to sue the federal government. In other words, this might be thought of as another element like the 10th Amendment, as something that protects a measure of state sovereignty by preventing states from being hauled into federal court when they're sued by a citizen of another state. Generally, you can get around this constitutional provision, by the way. Instead of suing another state, what you do is you sue a state official instead, say the governor or some office holder or bureaucrat. And that generally allows you to get into federal court. So this constitutional provision at least recognizes a measure of state sovereignty, saying you can't haul the state of Georgia into court, but you can get around it by hauling office holders in the state of Georgia into court.
Right. And this doesn't get involved with citizens suing each other, because that could be in either state court or in federal court.
That's right. The Constitution already has a provision that allows people of one state, citizen of one state, to sue in federal court when they sue a citizen of another state. The 11th Amendment does not challenge that provision.
Why do we have a court system, if you know the answer to this? Why do we have a legal system where I could sue, from Michigan, I could sue somebody in Florida in state court, let's say they owed me money, or I could choose to sue them in federal district court? Why do we have a system that allows for those choices?
Well, that's a very good question, and it comes really out of Article 3 of the Constitution that provides this federal forum for what they call diversity cases, a case where a citizen of the state of one state sues a citizen in another state. And the founders put this principle in the Constitution in part because they were fearful that if a citizen of the state of New York, for instance, had to sue a citizen of Georgia in Georgia state courts, that the Georgia courts would be beholden or partisan or biased in favor of the Georgia resident. And so the idea was that you should have the option of going into a federal forum, a federal court, where arguably you're going to get more equal treatment. So that was the idea behind that principle.
Although if you did go into federal court, you would still get a jury that's local to the court, though.
That's right, but you'd get a judge that was more likely to be neutral, in the sense that less likely to be beholden to local state interest, especially if you have a world in which state judges, as so many of them are today, are elected. If you're an elected judge in a state court, you might well be very, very sensitive to how the people in your community who are going to vote for you might interpret and see and understand your rulings. And if you're to rule in favor of those outsiders, those citizens in New York, if you're a Georgia judge and you're facing election, well, you might lose election for just, reading the law as you thought it was supposed to be read, rather than reading the law in the way the citizens of Georgia might like it. So certainly today with judicial elections, the idea of that federal form where the judge is not going to be elected might have more potential to protect against biased state court judges.
I think it's interesting. I don't know if people know this, but I think it's interesting how you don't actually have to be an attorney to be a judge.
That's right. There's no requirement in the Constitution that you have to be an attorney to be a judge. No real requirements in the Constitution of anything for a judge, whereas in contrast for the president, for instance, where you have to be a natural-born citizen who's 35 years or older. We don't have those kinds of limits on who could be a judge. And there have been some notably young federal court judges over the years.
Mm-hmm. All right, let's take on number 12. This one's a big one. Do you want to read this one, or how do you want to tackle?
I mean, I can read it, but it's a long, boring read. But
it's up to you. This is a tough one.
This is a tough one, and I think what we should do is probably try to simplify it a little bit. The 12th Amendment was adopted in 1804, so not long after the founding, and what it does is reforms the Electoral College. Of course, there's been a lot of conversation these days about the Electoral College in light of the fact that 2 of our last 5 presidential elections have resulted in the winner not being the person who won the popular majority's choice. And that's a result of the Electoral College. And while some think that the Electoral College is sacrosanct, that we should never tinker with the founders' approach to presidential elections, the founders themselves were a little bit more experimental, and they were willing only less than 20 years after the founding of our nation to change up the Electoral College. And this is one of 2 constitutional amendments that revamps the Electoral College. The key with the 12th Amendment is that there was a really troublesome election in 1800, and in part because of how the old Electoral College would work, which would be if you were an elector in the Electoral College, you would cast 2 votes for 2 different people. And the winner of whoever got the most votes would be chosen to be president. And the person who received the second most votes would be the vice president. But this often was starting to cause problems right away early in the country, because you could elect someone as president who was from one party and then elect a different person from another party to be vice president, and then you'd have a total mess.
Now, this happened with Adams and Jefferson, right?
That's right. This happens in that 1800 election.
And they were bitter enemies at the time.
That's right. And this provision's key reform was really to direct electors to cast separate ballots for the president and for the vice president, and provided special rules for if the Electoral College couldn't decide on a president, then the House would decide, and it wouldn't just automatically go to the second most vote getter. And so this was one of those important provisions that reformed the Electoral College, made it a little bit more sensible in how it went about choosing the presidency and, importantly, the vice presidency.
So is Amendment 12, is this Article 12, is this the way we're handling presidential elections today?
Not quite. Like I mentioned, there's been 2 constitutional amendments dealing with the Electoral College, the 12th Amendment and the 20th Amendment. And so we have the 20th Amendment provides more details and has revised it once again, the Electoral College, moving the presidential terms and addressing what to be done if we cannot decide on a president-elect in the Electoral College, new mechanisms for how to decide a contested vote. That's really under the 20th Amendment. When we turn our attention to the 20th Amendment, of course, that will raise the issue of Bush versus Gore, because at least some people argued at the time, well, there was no need for the Supreme Court to step in because the 20th Amendment provides a mechanism for how to decide contested presidential elections by sending it back to the House of Representatives. you should know, just to give a little spoiler alert, even had that mechanism been used in the 2000 election, it's clear based on the House delegations at the time that would have been called on to decide the issue that George W. Bush would have won the presidential election.
So when we look at the Electoral College, there's a lot of people currently on the Democratic side who want to abolish it and go to a popular vote. The right, the people on the right, they're concerned with getting rid of the Electoral College. Their belief is that without it, New York, California, Chicago, Texas would control the majority of all presidential elections for forever, which is probably true. What was in the founding fathers' minds when they created the Electoral College? What were they trying to accomplish?
Well, they were trying to come up with a balance, because that same concern that you've just articulated was a concern that the founders had too. There was concerns that at the time Virginia, which was the most populous state, would overwhelm presidential elections, and a little state like Delaware that didn't have a lot of people in it would be overwhelmed. And so there was, even back then, that concern for balancing the popular majority with states' rights and the recognition of the independent ballot interests of states. At the same time, I think the Electoral College no longer serves quite the same function as the founders imagined for it, in part because states now have laws that control how the electors in the Electoral College vote. So, for instance, many states have provisions that require the electors in their state to cast their ballots for the winner of the popular vote within that state. So if California voters choose a certain presidential candidate, then the electors have to vote that candidate. I think the founders' vision was very different. They thought that the electors would come together and debate and discuss and talk about these different candidates and have a measure of autonomy over who they cast their ballots for. And indeed, in early elections, electors did not always cast their ballots in line with the majority of that state. So the Electoral College is not playing the role that it still plays that role in balancing state versus different states, populous states versus not populous states, but the electors themselves don't play that sort of decision-making or deliberative role that the founders had imagined.
Were the founders actually thinking that these electoral candidates would sometimes be wiser than the public?
Well, remember, the founders had a very conflicting relationship with democracy. They believed that we should have more power to the people than had ever been had before, but they were very concerned that majorities would be rabble-rousers and would run roughshod over the rights of people. And so just like we say we have a republic, not a democracy, the founders didn't believe in a lot of direct action by voters. The Electoral College is one of those mechanisms that sort of tamps down the aggressiveness of popular majorities in favor of a more deliberative, slow-moving system.
So when we have a presidential election in this country, we have our constitutionally limited republic, and then we have 50 democracies. So we really have 50 democracies that are holding a presidential election. And then the results of each of those 50 democracies are now being used to vote in this constitutional republic. Is that correct?
I think that's right. That's right. And one of the odd things is just because like you talked about earlier, the different population in different states, you have some states that have, less than 600,000 people in them. And then you have a state like California that has almost 40 million people in them. And in the Electoral College, the power between those states is somewhat, not completely, but somewhat equalized and made more consistent with one another.
Right. So California still has way more congressional seats. So they have more votes because of that, but they still only have 2 senators.
That's right.
And every state has 2 senators, regardless how big or how small they are.
That's right.
So how would this, if we were to get rid of the Electoral College, and let me back up for a second. There is a number of states right now who have now passed state bills saying that their electoral votes will go to the winner of the popular vote on a national level.
That's right. This is an interstate compact. So one thing the Constitution allows is states to come up with sort of mutually binding agreements between themselves. And so, for instance, we have a 50-state compact where every state recognizes every other state's driver's license. Right? That's not because of a federal law. It's because of one of these compacts, agreements among the states. A bunch of states have come together these days to try to come up with a compact that would effectively get around this electoral college dilemma that we've been talking about, that the winner of the popular vote is not necessarily the winner of the electoral college vote. And so what these states have done is said, well, we will commit, assuming a sufficient number of states sign on, but we will commit that our electors will, when they go to the electoral college, they will vote in favor of the popular majority winner nationwide, rather than as it is today, right? I mentioned earlier, there are laws in place that require the electors to now cast their ballots in ways that reflect the majority vote of the state. This would change that and say, instead of looking to the majority vote of the state, you look who won the popular vote nationwide, and you have to cast your ballots for that candidate, even if the particular state voted for someone else. And so this is basically a way to reform the Electoral College, to move to a popular vote system, popular majority vote system, without having to amend the Constitution.
So, and this is in response to Hillary Clinton losing the 2016 election. So my question is, had this rule been in place, had these 15 states that have this been in place, then a state who voted for Donald Trump would still be casting all their votes for Hillary Clinton because she had the popular vote. So my question is, haven't we just negated the vote? I mean, why did that state even bother to have an election if they're only going to go with the popular vote anyways?
Well, presumably those states and the citizens of that state, their vote will be part of that popular vote majority, right? Their votes are reflected in the ultimate tabulation. But you are right that you could have a state that signs on to this compact where the voters all vote, or not all vote, but a majority of the voters in that state vote for, say, the Democratic candidate, but the electors would then go in and cast their ballots in favor of the Republican candidate if the Republican candidate got the most votes nationwide. So it doesn't undermine the democracy of that state in the sense that the voters in that state still count. They count for the overall popular majority. But it does make the vote of the state as a state almost entirely irrelevant. And I think that's the point, right? Because if we have state by state voting, you have states like North Dakota and South Dakota, two small states that don't have very much population, having at least arguably an outsized influence on the Electoral College. And voters in a place like California have much less of an influence per voter than a voter in South Dakota does. So any way you look at it, someone loses, someone wins, whether you move to a popular majority or you keep our current system, there's no perfect way of figuring out who should get the votes. But this is definitely an area where we're seeing a lot of discussion and some real efforts at trying to rethink how we might do presidential elections.
So in the upcoming 2020 election, just for the sake of conversation, let's say that we had a Democratic candidate who once again had more popular vote, which again is not hard to do when you have a highly Democratic state with 40 million people in it. But let's say that the Republican candidate would win the Electoral College under its current model. But now all of a sudden we have these 15 states that are saying they're going to pledge their vote to the majority. Would that result in a Supreme Court challenge, and how do you think that would fall?
So I don't think so. So first of all, just to clarify, the 15 states, the compact does not kick in until I think a threshold of like 36 states adopt the compact. So
that's the same number of states as the gun permit compact.
Yeah, I think it could be right. Yeah,
It is.
and so the 15 states are not going to change their voting techniques right now. It's contingent upon more states joining the compact. But you could have a situation where you have more states join the compact, and the compact rules do kick in, and that leads to a Supreme Court challenge. You could imagine, at least conceivably, that the Supreme Court would say, no, that you cannot do this because the framers envision the electors at the Electoral College to have some discretion over who they voted for. But that would, by the way, also call into doubt current laws that say you have to vote in light of the popular majority vote of that state. And that would actually might do a lot to reform the Electoral College, because I think states would start to be really worried. Imagine if you were a state in 2020 that voted for, as a majority of your state, voted for Donald Trump, but your electors went in there and said, you know what, I don't like Donald Trump, I'm not happy with his presidency, and I'm going to cast my ballot the way I think it should go, rather than the way the voters of my state should go. You might really see efforts to reform the Electoral College then.
Now, the electors, just so people understand, even though they're counted out, let's say, based on congressional seats and Senate, the members of Congress and the Senate are not the Electoral College. They're not the people voting.
No, that's right. There are special electors who are chosen. Basically, you choose them when you vote. There are people who submit themselves to be electors at the Electoral College. And these days, it's mostly a symbolic role because your vote is required to follow the mandate of the state voters. But you could imagine if a challenge to the Electoral College were successful and the Supreme Court were to say, no, you can't limit electors in this way. Then we would have people who would be selected for the Electoral College that really could do almost anything they want.
So I could
and frankly, that may be what the founders imagined.
I could see that in the future, if this was able to happen, there would be major campaigns all over the country, people competing to become that Electoral College member then.
That's right.
That would
maybe
be a
instead of voting for
factor.
Right. Instead of voting for the Republican or the Democrat presidential elector, you'd seem to be voting for the electors. In fact, you really are doing that. You know, when you go into the ballot booth and you choose Hillary Clinton for president or Donald Trump for president in 2016, you were really choosing a slate of electors that have been chosen by the Republican Party to vote if you're voting for Donald Trump or if you're voting for Hillary Clinton. So in some ways, you're already doing that, but this would be a more formalized process, and that would be a very interesting, different kind of presidential election to have.
Now, you said that the compact between the states requires 36 states.
I believe so. I'm gonna let me just add a grain of salt. I didn't look at that compact right before this interview, so I'm just going by memory. That's the number. It's somewhere around that number. If it's 36, maybe it's 37.
Where does that rule come from?
Oh, that's just in the compact itself. It's not a rule. It's just part of the agreement itself that the compact will not become effective until enough states have committed their electors. And you can understand why. No state today says, hey, we're going to give up our state authority over voting by turning it over to the popular vote, unless a lot of other states are going to do that too. We're not going to unilaterally disarm. We'll just require others to do it. It's really just a matter of a contractual agreement, and these are one of the terms of the contract.
Okay. I was curious because as I was saying, the reciprocal gun pact is 36 states. So I was just curious if that was by design or coincidence or how that happened to be the same number.
I think in terms of the 36 states for the gun compact, I think it's just a matter of there are 36 states that have signed on. It's not a requirement, and I think that the gun reciprocity compact was viable and effective even before it hit that number. It was not one of these that required a bunch of states to adopt it, and for good reason. You might imagine two states, say Florida and Utah, that just say to each other, hey, if you're residents come to our state, they can carry a firearm if they have a concealed carry permit, no problem. You don't need to worry till you get some critical mass of states to do that, to accept those gun permits. When it comes to the elections and the popular vote, however, well, you can imagine states don't want to give up their state authority unless all the other states are going to do it too.
Yeah, and I think you're right about the gun permits because I believe that states have been more recently added to it. So what else do we need to know about the 12th Amendment?
Well, that it's right before the 13th Amendment, which marks the 13th, 14th, and 15th Amendments, the last three that we'll cover today, are really some of the most important amendments of the Constitution. These are known as the Reconstruction Amendments, and that is to say they were adopted, these three amendments, right after the Civil War to revise American government and to sort of reshape. Some people have even called the Reconstruction and these constitutional amendments America's second founding, because these amendments so changed American life and so changed the American Constitution.
And these three amendments came fairly close to each other, right?
That's right. They were adopted between 1865 and 1869, just sort of in rapid succession. Of course, they happened rapidly, but they did require a civil war and hundreds of thousands of lives to be lost before the political will was there to adopt these provisions. And even then, some of the provisions really didn't have much popular support at the time.
So we go to the 13th, neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, comma, shall exist within the United States, comma, or any place subject to their jurisdiction. So that one's pretty clear.
This one's pretty clear, right? This is designed to overturn and outlaw slavery after the Civil War. Some people think that slavery ended with the Emancipation Proclamation that was issued by President Abraham Lincoln in 1863. That's often the thing people look at. But the Emancipation Proclamation was actually quite limited in its scope. It only freed those slaves that were held in the 11 Confederate states that had seceded and declared war on the Union. There were two other slave states that did not secede from the Union and did not join the Confederacy. The slaves in those states were not touched.
All right, so let me get
really
this straight.
A wartime measure.
So when President Lincoln issued the Emancipation Proclamation, he wiped out slavery in the South, where he technically wasn't in charge at the time, but he left slavery in place in the North?
That's pretty much what happened. And this was justified. So first of all, the president, Abraham Lincoln, could not have issued a proclamation freeing the slaves in the North, right? I mean,
right.
The president doesn't have the power to just adopt laws that do something like change your property relationships or free slaves. The president doesn't have that power. Congress might have that power, but Congress would have to enact the law, not the president. And the Emancipation Proclamation was not passed by Congress. It was subsequently approved by Congress, but only after it had been issued. It was really a wartime measure, a measure for controlling the battlefield and the field of war by saying that any slaves in the southern area in the field of battle were automatically freed. Of course, it did not have the effect that some might have hoped, right? Because the southern states, the Union was not in control of the southern states. But it did provide real hope for many people in the South, especially African Americans, that they could gain slavery as a result, gain freedom from slavery as a result of the war, and certainly change the war fundamentally from being one about states' rights, which had always been a really predominant aspect of the Civil War, into one more clearly about slavery.
So it was really a political weapon.
A political and a military one, but that's right. The Emancipation Proclamation was a political and military effort, and not necessarily one that was in accordance with the Constitution. It's always one of the hard things when you teach constitutional law to examine some of the things that the great Abraham Lincoln did in the name of the Constitution. Because Abraham Lincoln, widely regarded by everyone as the greatest president in American history, actually played fast and loose with some of the Constitution throughout the Civil War. And granted, it was a tough time, and it was the Civil War after all. But the Emancipation Proclamation has always been thought to be on somewhat shaky constitutional grounds. But the 13th Amendment alleviates any real issues with that. It outlaws slavery or involuntary servitude. Interestingly, about the 13th Amendment, something we've mentioned before, is that the Constitution is a limit on government and not a limit on private parties. That is to say, the government cannot restrict your freedom of speech. But if your mother wants you to go to church on Sunday, you're going to go because the Constitution does not protect you against your mother. It only protects you against the government. The 13th Amendment is the only constitutional provision that restricts the rights of private citizens. It says that even private citizens cannot hold another person in slavery, even though it's not the government doing it.
So, sticking with this Reconstruction period for a moment, did the South have the right to secede from the Union?
Well, of course, that's a subject of much debate. You know, there's nothing in the Constitution that makes clear whether the South or any state has the right to secede from the Union. Right? It's just not really clear cut in the constitutional text itself. There were those who argued in the South that they did have the right to secede, that the Constitution was a voluntary compact of independent sovereign states. Of course, the Union and Lincoln rejected that idea and said that there wasn't a right to secede, that this was a more perfect Union that was intended to endure for ages to come, and that we resolved our problems within the scope of the Constitution and its structure. Of course, the Union wins that argument by force, and today it's widely accepted that states do not have a right to secede from the Union, certainly not without the approval of the other states.
Because we do know that there's a very active movement in Texas called Texit, which actually predates Brexit, to get Texas to actually secede from the Union.
Hey, and if Donald Trump wins re-election in 2020, California might be trying to secede from the Union next. We might have a whole bunch of states trying to do this in the near future. But it seems highly unlikely that the courts are going to allow secession. Indeed, the last time it did get pretty messy, so I don't imagine any state's really going to push too hard to do it now.
Now, did the Supreme Court ever hear the case of the South?
No, never did, never ruled on whether the South had a right to secede from the Union or not. It remains just one of those issues we continue to debate. And like I said, arguably was sorted out on the battlefield. Had the South won, then the right to secede from the Constitution would have been clear. But the South lost, and ever since the right to secede has been thought to be sort of more of a fringe position rather than a mainstream one. But again, the text of the Constitution is pretty silent on the question.
And the reason the Supreme Court didn't hear it, is it basically because the South never brought a case?
Well, remember, the South did not view itself as under the jurisdiction of the Supreme Court anymore.
That's what I'm saying.
They had seceded.
Right.
So there was no case to be brought.
Okay.
They did not believe themselves to be part of under the Supreme Court's guidance. And indeed, these issues about the power of the federal government versus the states really came to the forefront in the 14th Amendment when it was proposed. The 14th Amendment, which says that anyone who's born in this country and subject to the jurisdiction of the country is a citizen and requires equal protection of the law, important provisions outlawing discrimination, for instance. That provision, when it was proposed to the states, was rejected by most of the southern states. And as a result, because they couldn't get this amendment passed, Republicans in Congress basically refused to recognize the lawful state governments that were in place and replace them as a part of a military act and during Reconstruction with all new governments that had lots of African Americans participating in them, for instance, and waited until those new governments passed laws recognizing and passing and ratifying the 14th Amendment before it was added to the Constitution. So this is one of those provisions that even after the Civil War ended, states were not really entitled to sovereignty to choose whether to accept it or reject it. This was forced upon the states, and today it remains a very important constitutional principle.
Yeah, our Amendment 14, Article 14 is pretty big. There's actually 5 sections to it. So when we look at the first part, we talk about all persons born or naturalized in the United States are subject to the jurisdiction thereof and are citizens of the United States. How does this, when we talk about sanctuary cities, as we were speaking earlier, how does this play into people who are illegally in the country then? Are they not subject as citizens?
Right. So this is a really big question these days. Sort of the historical purpose of this clause, it's called the Birthright Citizenship Clause, was really to overturn the Dred Scott case, an 1857 case before the Civil War, where the court said that African Americans could not be citizens under the Constitution. And this very obviously overturns that decision by saying, no, all persons who are born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So this overturns Dred Scott, but that's the historical purpose. The recent controversy is over the children of undocumented immigrants. One view holds that that the children of undocumented immigrants should not be entitled to birthright citizenship under this provision. Now, I will admit, I think this is a hard position to maintain in light of the text of the amendment. It does say all persons born or naturalized in the United States. Some proponents of this view nonetheless say that that clause, subject to the jurisdiction thereof, distinguishes the children of undocumented immigrants, and says that they're really citizens. If they're citizens of other nations, not ours, then they shouldn't be protected by this provision. What the Supreme Court has said over the years, though, is that the straightforward meaning of subject to the jurisdiction thereof is, are you liable to be punished if you do something wrong by that government? So if you commit a federal crime, can you be arrested and put in jail for that federal crime? And it's clear that the children of undocumented immigrants are indeed subject to the jurisdiction of the United States. In contrast to, say, the children of diplomats who are born in the United States. Generally, diplomats are not thought to be subject to the jurisdiction of the United States. If they commit a crime, they can't be arrested for it. They can be kicked out of the country, but they can't be arrested and put in jail for it. But certainly the children of undocumented immigrants can and are on a daily basis imprisoned for violations of federal law. So clearly are subject to the jurisdiction of the United States.
So I'm going to say something that's probably very unpopular amongst a lot of people on the right, but that is the concept of the anchor baby, as an example. So the family who illegally enters the country, and then a child is born within the boundaries of our country. That child, when I look at this, that child's a citizen.
And that's what this provision was really designed. It wasn't designed specifically for the children of undocumented immigrants, but it was designed to prevent sort of that idea of a permanent underclass, that we would have people in this country, large numbers of people especially, that would not be citizens, that would not have the rights of people. We had that before in the slavery era, and this amendment was adopted in part to be sure we never have that again. And I fear that if we say that the children of undocumented immigrants are not citizens, that we're going to create a permanent underclass of people who have no rights and who have no sort of legal status in America. I think the framers of the 14th Amendment were very concerned about that and tried to stop it.
I think it would be very hard to argue that a person born on our soil is not an American. I think
especially if they're not a diplomat. I mean, and that's that jurisdiction language, right? I mean, certainly if you're the son of the Russian ambassador and you're born in the United States, the old law is that you're not an American citizen, you're a Russian citizen.
Right, but the embassy is also Russian soil too, though, in that case.
Right, that's all a very unusual kind of situation. And I think that there are there are notable constitutional scholars who do view the Birthright Citizenship Amendment differently and who do think that this amendment does create room for denying citizenship to the children of undocumented immigrants. John Eastman, for instance, at Chapman Law School is a very notable conservative scholar who makes this argument. I think it's pretty tough given the language of the text of the Constitution. You have to kind of ignore the text a little bit to get there. But there are those who are making that argument and do so and have at least a plausible basis for such a claim.
Now, let me give you the flip side of this. Flip side is someone breaks into our country or illegally enters our country and they commit a crime in our country. Are they now subject to our due process laws? Because they're not a citizen.
That's right, but they are subject to our due process requirements. Indeed, if we turn our attention just a few words down in the 14th Amendment, we have a due process clause, and it says, nor shall any state deprive any person of life, liberty, or property without due process of law. It does not say you cannot deny any citizen life, liberty, or property. It says any person of life, liberty, or property without due process of law. And so that language, again, the text of the Constitution requires any person who's going to be deprived of life, liberty, or property to be done only in accordance with due process of law. So that would certainly apply to, say, an undocumented immigrant who's here in the United States who commits a crime.
This really points out the necessity when looking at the Constitution and the law of really parsing every word, doesn't it?
That's right. I mean, the text of the Constitution is really an important document and really the baseline for how we interpret the Constitution. I think one of the amazing things you find is that how few people in America on both the left and the right really take the text of the Constitution seriously. Some people claim to take it seriously, but really, when push comes to shove, many of the provisions of the Constitution may weigh in favor of conservatives today and Democrats tomorrow. These principles really should be timeless, and the principles are the ones that are articulated in the text.
So when it says that nor shall any state, and the state is a capital letter, nor shall any state deprive any person of life, liberty, or property without due process of law, does that mean the federal government would not be limited by that, since it is not a state?
The federal government is not limited by this provision of the Constitution. That's right. This provision only applies to states, not to the federal government. It does apply to local governments that under the Constitution are deemed to be part of the state, but does not apply to the federal government. However, bring us back to our show a couple weeks ago or a month ago, we talked about the Fifth Amendment to the Constitution. Well, the Fifth Amendment to the Constitution, which is directly a limitation on the federal government, also has a due process clause that reads almost exactly the same way, and that it requires, it says that no person shall be denied of life, liberty, or property without due process of law. So both the federal governments and the state governments each have their own due process clauses in the Constitution, but they are effectively the same and provide the same protection for any person.
So would this be why, let's say, an illegal alien or undocumented person was arrested for burglary, then the state, county, or city that caught this person wouldn't have the authority to deport them? Only the federal government would have that authority.
That's right. There are provisions of the Constitution dealing with naturalization that give that power to Congress, and the Supreme Court has held that also includes the power of immigration control. And so states could arrest someone and turn them over to the federal government, but they couldn't deport someone on their own.
But when we go back to, I believe it was the 10th Amendment, that means that the state doesn't have an obligation to have its law enforcement officers function on behalf of the federal government.
That's right. That's right. So states can choose not to enforce that federal immigration law, even though the Constitution gives the general power of immigration to the federal government. Again, this is one of those sort of things that sort of falls through the cracks, if you will. You've got this system in which the federal government has power, but that power is limited. And sometimes it means what it can't do is force states to do what it wants to do. And that might be good for federalism, but like I say, that is good for the right on issues of guns and good for the left on issues of immigration and drugs. And tomorrow it'll be good for, someone in the middle on some other issue. But it's one of those issues that does sort of fall between the cracks of federal and state power.
Yeah, so when we look at the sanctuary city issue, which, clearly most conservatives and Republicans are not in favor of, it would appear that the sanctuary city or sanctuary state model is on relatively sound ground.
Well, indeed. I mean, I will say there are those who argue that the Supreme Court has gotten it wrong in this space and that it should not have said that the federal government can't force state officers to enforce background check provisions either. So there are those who believe that the court has gotten it wrong throughout all of these cases and that the federal government should be able to order state officers to enforce federal laws, whether it be immigration law or gun laws or drug laws. Like I said, that view has not caught on with the Supreme Court. And the current principle is one that does seem to provide a little bit for both sides of the political aisle.
So the second section of the 14th Amendment, what does that tell us?
Just don't want to overlook too much that one other important provision of the first provision of the 14th Amendment, which is the Equal Protection Clause, the guarantee that nor shall any state deny to any person within its jurisdiction the equal protection of the laws. This was obviously one of the most important provisions of the Constitution in that it deals with that touchy issue of race. And this was the basis of the Supreme Court's decision in Brown versus Board of Education that said you cannot have intentionally racially segregated schools because that was a violation of the equal protection of the laws. And this Equal Protection Clause continues to be really at the forefront of constitutional arguments, for instance, in issues of gay rights. Does a law that prohibits or that only allows opposite-sex couples to get married and does not allow same-sex couples to get married, is that a violation of equal protection of the laws? The Supreme Court in the Obergefell decision a couple years ago held that it was. And so a lot of issues of sexual orientation discrimination, of discrimination against transgender students, discrimination on the basis of age, disability, and gender and sex, all come under the Equal Protection Clause. So this is an important provision that really plays a fundamental role, a starring role, if you will, in so many of our controversies.
You know, one thing that hits me about our country and our Constitution is we have this great framework, but we didn't get it right. We didn't get it perfect. And that we were not a perfect union or a perfect country. We had slavery, we had different issues, but it shows how as a nation, we keep evolving and trying to fix the things that we find wrong.
I think that's a very, very profound statement because some people, the Constitution is worthy of our respect, but sometimes we emphasize too much the founders back in 1787. Now, they were obviously, incredible visionaries that are worthy of much respect, but the genius of the Constitution is not just in what they did in 1787, but also in the 17 amendments that we've adopted since then, that's not including the Bill of Rights, the first 10 of amendments, but overall 27 important constitutional amendments that have been adopted to the Constitution, including these things like requirement of equal protection of the laws. The founders did not protect against discrimination. It was only after, almost 100 years after the founding, that we added that principle to the Constitution. It was only later, and maybe we'll get to it in our next episode, where votes for women were granted by the Constitution. And so we recognize that the Constitution, to make it this great document that governs our society, does need to be updated occasionally, and we have done so in recognition of a broader array of rights than we ever could have imagined at the founding era.
That's what I think is so amazing about America, about the United States in general, that we're not perfect, but as we identify our errors, our failures, we try to fix it. And I think those 17 amendments are kind of the evidence of that we try to fix it.
Absolutely, and none more so than these 3 amendments adopted after the Civil War, which really did radically change the government. One of the things that this 14th Amendment does that is easy to overlook but is vitally important is, you may remember from an earlier episode, we talked about the fact that the Bill of Rights, the first 10 amendments of the Constitution, were only originally limits on the federal government and were not limits on state and local governments. It wasn't until the 14th Amendment added these provisions that restricted the power of states to deny due process of law or to deny citizenship or to deny equal protection of the laws. It was only after this amendment was adopted that states were required to respect the principles of the Bill of Rights. And indeed, if we had the old Constitution that the founders had, the state of Boston or the state of Texas could restrict freedom of speech without any constitutional problem whatsoever. Or they could restrict your Second Amendment rights, your right to have a gun under the Second Amendment, because it would only be a limitation on the federal government. The 14th Amendment makes most of those provisions applicable against the states too. So the reason why a Californian or a Texan has a right to bear arms today is in part because this 14th Amendment broadens what was originally just a limitation on the federal government and makes it a limitation on all governments.
Okay, so Section 2 of the 14th Amendment, we're talking about representatives, right?
That's right. The most important thing about this Section 2 is that it seems to play a role in the current controversies over felon disfranchisement, about whether a state can prohibit felons from exercising the right to vote. And of course, when we say felons, we're talking about people who've already served their sentences.
Right.
Might think of them more as ex-felons. No one's saying that felons in jail are going to have the right to vote. The question is whether someone who is a felony conviction but is then out of jail. And many states say no, felons cannot vote. And this Section 2 of the 14th Amendment is what they look to. It says that it seems to recognize that if the right to vote is limited by any state, then that state will lose some of its representation in Congress. However, it also says that that this rule would not apply if someone is denied the right to vote for participation in crime. And as a result, the courts have said that if a state limits someone's ability to vote because they have been a criminal, that does not pose any constitutional problem.
So would that make the right to vote a state issue then, the right for a felon to vote?
That's right. It leaves it to states to decide whether felons should be allowed to vote or not.
Now, this also, I think this is also interesting that this also names male citizens of 21 years of age, which obviously that changes later on in the Constitution.
Indeed, this is actually this provision talks about male inhabitants being denied the right to vote, and if they are, then that state will lose representation in Congress. And this was the first provision of the Constitution that used the word male. Right. And that subsequently denied women some of the rights under the Constitution. And this led to, when this 14th Amendment was proposed, this led to the famous progressive leaders of the women's rights movement, Susan B. Anthony, for instance, and Elizabeth Cady Stanton, to oppose the adoption of the 14th Amendment because they thought that this amendment should be protecting women's right to vote too, and not just the right to vote of men.
Right. So even during the Reconstruction, we still didn't get it right yet.
Definitely still didn't get it right. And indeed, even though the Constitution was better than it was before the Civil War, we of course know that we got 60, 70 years of Jim Crow laws after the Civil War. So we know the Constitution, whatever its text said about equal protection of the laws, didn't mean much if we, the people, weren't willing to make that reality or make that a reality.
Now, what does Section 3 tell us?
Well, we get into Section 3 of the 14th Amendment. Again, more of the sort of the details of the 14th Amendment, not sort of the keys that everyone focuses on in terms of the 14th Amendment, which really do tend to be the Equal Protection Clause and the Due Process Clause, etc. The Section 3 of the 14th Amendment basically provides that no one who was engaged in the rebellion of the Civil War shall be entitled to be a representative in Congress, an elector in the Electoral College, or hold any office, civil or military, under the United States or under any other state.
So, I mean, is this kind of a moot point now?
Yeah, no, this one is not one that still has much impact, obviously. It's about people who had once said that they were going to swear allegiance to the Constitution, took the oath of office to the Constitution, and then rebelled. And if you did that, this one says, okay, well, you can't come back. You don't get to serve in office again and swear you're going to hold an oath of loyalty to the Constitution. You've already violated that oath. We don't trust you. So that's no longer a key provision. And then we turn our real attention to the 15th Amendment, right? Which provides...
Well, let me ask you a question before you jump there. On the Fourth Amendment, is that really an extension saying that the nation is also not going to pay the debts of the South?
No, so Section 4 of the 14th Amendment?
Right.
Yeah. So this one says that the validity of public debt, including debts incurred for payment of pensions and bounties involved in the rebellion, shall not be questioned. This was always a big issue in warfare in the early times of American history. Of course, how did you pay for the debts that were incurred during the War of of independence was actually a big, big issue in early American life. And again, it became an issue after the Civil War. There was some political movement at the time to say, hey, you know what? A state should just be able to cancel those debts. If it borrowed money, for instance, so it could fight the war. And this provision says no, the public debt of the United States shall not be questioned. And so this one basically takes off the political table efforts to try to say that you don't have to pay these debts, that these debts are not legitimate debts.
All right, so let's go to our last one, number 15.
Number 15, the 15th Amendment is a very straightforward and simple amendment that unfortunately has had a very troubled history. It says that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. And of course, the purpose of this provision was to enfranchise African Americans and anyone else who was a citizen and could not be denied on account of race, color, or condition of servitude. But the history of the 15th Amendment shows that constitutional rights can really be sometimes nothing more than words on paper, unless we, the people, are willing to stand up and fight for those rights. And of course, African Americans, although in the first 20 or 30 years after the 15th Amendment was adopted, there was a lot of voting by African Americans in America. Around the 1890s, that's when things started to go the other way. And African American voting, especially in the South, but not exclusively in the South, but especially in the South, was restricted and eliminated. And indeed, by 1915, you had elections in the South where not a single African American was allowed to vote. So this is one of those amendments that for many years did really not do what it was said to do, which was to protect the right to vote. African Americans really didn't win the right to vote in America fully until the adoption of the Voting Rights Act in the 1960s, which did far more than the 15th Amendment to protect the right to vote on the basis of race.
So, Professor, there is a lot of controversy right now about asking voters for identification. What would be the constitutional argument for that or against that?
Well, one argument that's been made against these voter ID laws is that they effectively are a violation of the 15th Amendment, that they're a denial of the right to vote on the basis of race. Now, at least self-evidently, superficially, these are not restrictions on the basis of race, right? You're not said, well, you can't vote if you are African American. It says you can't vote if you don't have one of these forms of identification. So it's not strictly on account of race. Some have argued, though, nonetheless, that the kinds of provisions that are being adopted very specifically to restrict the voting and voting strength of African Americans. Maybe not because they're African Americans, but because they're arguably Democrats. And there's, of course, a strong correlation between African American population and voting Democrat. And so that's the argument, that this effectively violates the 15th Amendment by making it harder for African Americans to vote. I think that argument hasn't won much sway in the courts, in part because, at least technically speaking, no one's being denied the right to vote on account of race. They're being denied the right to vote on account of something else. Could recognize, nonetheless, of course, back the role of things like literacy tests back in the early 20th century, which denied African Americans the right to vote, too, not on the basis of their race, but on the basis of illiteracy. And so we do have a long history of using quote-unquote race-neutral means to effectuate racial discrimination in voting.
You know, correct me if I'm wrong, but when I hear that African Americans are going to be disenfranchised by having to present identification, to me that sounds racist on its very basis, that someone is saying that African Americans are less capable of obtaining ID.
I think it's you could view that as about a capability. I think the proponents of the argument might emphasize instead this is not about capability, it's just about descriptively whether they have IDs. So for instance, the reason why I have a government issued ID is for two reasons. I have a driver's license because I drive a car, and I have a passport because I travel internationally. But there's a lot of people in America, especially poor people and poor minorities, who don't drive a car, who can't afford a car and don't have a driver's license because they never had any reason to get a driver's license. And they don't have a passport because they've never traveled abroad and don't have the money or the resources to travel abroad. So if I'm one of those people and I don't have a government ID, the idea is, well, now I have to go and make some heroic efforts to try to get some kind of ID. And maybe it's not that heroic, but hey, I don't like to go to the Department of Motor Vehicles any more than I absolutely have to. It's a pain, I got to tell you. I think so. The idea is not that they can't they're incapable of getting the ID. It's just that in the circumstances of their lives, they don't have that ID. And so enacting a law that requires them to have it when we know those people will not have it might be a kind of form of racial discrimination. But it is, like I say, it's not an argument that the courts have accepted, or do I think the courts are likely to accept anytime in the near future.
Yeah, I think a lot of people look at that and say, well, geez, how can you function in America without ID? You can't cash a check without ID, or maybe even buy alcohol without some kind of ID sometimes. So, I mean, it seems like it would be pretty hard to function in this world without identification.
Well, I would seem to think that's right. I use my ID all the time. But I guess, I wonder if, maybe that's just my privileged lifestyle, that the lifestyle I lead is one where I can't get along without ID. But maybe if you don't drive very often, if you're not someone who goes to bars a lot, or if you're like me, I don't get carded at the bars when I go anymore now that I'm over 50. Maybe ID is not doing that much work for me there. But you're right. You think that there's a lot of places where you might need that identification for some purpose. But I guess there's a lot of people in America who really don't have a need for identification other than when it comes to Election Day.
Well, Professor Winkler, we appreciate you being on with us today. We will pick up where we left off. So on our next episode in a month from now, we will start with the 16th Amendment. And how far will we go on that one? How far will we get on the next show?
We should do the 16th through the 19th Amendments in part, and I don't say this because I know it's going to upset you, but we call those the progressive amendments to the Constitution. 4 amendments that were adopted in the progressive era that very much changed American government in a way that made it more responsive to the people. And in many ways create a much stronger federal government, much to the dissatisfaction of conservatives in America.
Well, when I think of conservative, when I think of myself, I would probably fall more into camp of what might be referred to as a libertarian. So I kind of come from the position that you and your same-sex partner should own machine guns to defend your pot farm.
Well, you're not going to like our next episode then, because the 16th, 17th, 18th Amendment, and 19th Amendments are not libertarian amendments. The Income Tax Amendment and the 16th Amendment leads to the creation of big federal government programs. And of course, the 18th Amendment outlaws the sale of alcohol, which is exactly the opposite of a libertarian amendment.
Yeah, that didn't work out, did it?
It didn't work out, but nonetheless had a huge impact on American government.
It did. Well, folks, that's it for today. Thank you, Professor Winkler. We will have, if you go to the show notes, you'll find this episode. And folks, I want to remind you, this is the first one of the Professor Winkler episodes you've listened to, go back and start at the beginning and work your way through all the episodes, because I think this is episode 7, I believe, at this point. And there'll be links to his social media and also to his books, because the professor has several wonderful books out, even one that was a recent Jeopardy question. Thank you, Adam. That's it today for Blunt Force Truth. If you enjoy the show, please remember to go to Stitcher, iTunes, leave us a good review. And, of course, you can find us on the Podcast One app on your phone if you happen to have that. And Chuck will be back with us next week here on Blunt Force Truth.